You are listening to PowerScore's Law Practices podcast series. Today's topic is the practice of intellectual property law. On the program, you will hear from Jerry Fellow, shareholder at Greenberg Traurig, and Lewis Gould, partner and chairman of the Patent and Trademark Practice Group at Duane Morris. Intellectual property law can be explained in many ways. Our guest today mentioned two main parts of intellectual property, being patents and trademarks. Our first guest, Jerry Fellows, discusses what he believes to be the definition of intellectual property law.
Intellectual property law covers a lot of different creations of the mind, essentially, and there are various laws and regulations that provide some type of protection and exclusivity for those who create intellectual property. So what people often refer to as intellectual property include patents, trademarks, copyrights, and trade secrets, but it is more inclusive than that under some of the broader definitions.
Our second guest, Lewis Gould, also gives his take on intellectual property law.
Intellectual property law is that area of law that protects the property rights of individuals and corporations that come from, if you will, in the case of patents, from the act of invention, making an invention and getting it protected, both through the patent office and in the courts if a patent needs to be enforced, as they frequently do. And on the trademark side, it is protecting brands, names that are used to identify products and services, like Coca-Cola for soda and McDonald's for restaurant services. So it's protecting all of the assets that are owned by individuals or corporations, which are not hard assets in the terms of a building or a machine or anything else that's used by individuals or corporations to make money.
For students who are considering intellectual property law, Jerry suggests that this is a specialty that will continue to be strong, and even potentially strong through a legal recession.
They should know a couple of things at least. One is that you do not have to have a technical background in order to practice intellectual property law. In fact, probably the majority of people do not have technical backgrounds who are doing exceedingly well in intellectual property law. I think also they should know that best we can tell, the demand for intellectual property lawyers is going to continue to be strong. So while it's not completely recession-proof, it also isn't as cyclical as some of the practice areas, and intellectual property is increasingly important to global competitiveness and is receiving increasing attention from governments as well. So we see, if anything, demand continuing to be strong and potentially increasing as well.
Lewis says there are two sides of intellectual property and suggests that students understand what is needed for both.
Let's talk first about the field of intellectual property law relating to patents. In order to practice as a patent attorney in the United States, you have to take and pass a bar examination, which is given by the Patent and Trademark Office. And this bar examination is in addition to any state bar examination that you might take in the state where you intend to have your practice. There is a requirement made by the Patent and Trademark Office as a prerequisite to taking the patent bar exam. And that prerequisite is that you have, as an undergraduate degree prior to going to law school, a degree in the sciences. It can be as an engineer. That's typical as an engineer, electrical engineer, a mechanical engineer, a chemical engineer. Can be a software engineer today. That's quite typical. But unless you have the requisite number of credit hours in the sciences that the Patent Office requires, you cannot sit for the patent bar exam, and therefore you cannot become a patent attorney. You can, without taking the patent bar exam, practice in the sense of being a trial lawyer, dealing with patent issues without being admitted to practice before the Patent and Trademark Office. Some lawyers do that with good success. Most, I think, trial lawyers who specialize in patent cases are also admitted to practice before the Patent and Trademark Office. So you need to have a science background in order to take the patent bar exam, in addition to having graduated from a law school.
The other side of intellectual property, Lewis says, is trademarks, and suggests that this side may be a little more popular because of the no extra bar exam required.
There is no corresponding requirement on the trademark side of the Patent and Trademark Office. You simply need to be a lawyer admitted to practice in a state where you are conducting the practice of law, and then you can practice before the Trademark Office in the sense of preparing and filing trademark applications and doing oppositions and that kind of thing.
So once you've decided you're interested in intellectual property, our guests offer some suggestions on how to become more prepared. Jerry says analytical skills are very important.
Well, really a broad-based background is helpful. If they already know that they want to, for example, be a trial lawyer, intellectual property litigation is booming now, they probably want to take more litigation-related classes. But if they haven't really focused yet or determined that they love litigation, for example, then good broad-based education is always helpful. Some of the administrative law courses are can be helpful, but it's really mostly about the analytical skills. And then some schools do have some intellectual property curricula that certainly students who are very interested in intellectual property law should avail themselves of.
Lewis says that survey courses in intellectual property is a good way to start your knowledge building of this practice. But he also says that students who are looking for clerkships should take more than the basic survey course.
Well, many law schools today, not all, but many law schools today do have curriculums which include courses in patent law and in trademark law and in copyright law. Some have courses in licensing, both in terms of patents and trademarks. Some have copyright courses. I think most law schools probably today have what I would call, a survey course in intellectual property, something that would touch on the topic of patents, the topic of trademarks, the topic of copyrights. But certainly from my vantage point, what I look for in terms of people who would wish to work here in a summer program, be a law clerk here, apply for a position as a starting associate, I would expect that they would have taken more than a survey course. They would have taken courses that are available to them dealing individually with the topics of patents, individually the topic of trademarks, same for copyrights. Doesn't necessarily have to do a copyright course, but certainly a patent course and a trademark course. There are schools like Franklin Pierce up in Concord, New Hampshire, which I think has now been acquired by the University of New Hampshire, has an excellent patent and trademark program for law school students. I know Penn State Dickinson does. I know Villanova does. There are many schools that do. Temple University Law School does. So most of those courses are taught by adjunct faculty, people who are actually practicing in the field of patent and trademark law. So I think they get, I think they do try to make available for students who may be interested in patent and trademark law the requisite courses that I think would give them, a good foundation on which to start in that practice area.
Since we're featuring a different law practice every month, one question that is pertinent is what makes each specialty unique? And Jerry says intellectual property is unique because it's very broad, and it's filled with lots of opportunities.
The way it's unique, it depends on really which area. Oftentimes people will specialize they'll do a lot of patent work and less copyright and trademark work, for example. But you can find your niche within intellectual property. It is a very broad field with a lot of different opportunities. So you can pick and choose whether or not you want it kind of contentious type of a practice, where, in other words, where you are in court a lot, you are resolving litigious disputes, if you like, within the purview of intellectual property law. But you can also pick various areas where it really isn't contentious. Certainly, if you're doing a lot of things with the Patent and Trademark Office, either patents or trademarks, or if you're getting copyrights for people, that is something that is much less contentious. Oftentimes, you're both looking for a good solution. There's some negotiation, but it's very it's not supposed to be contentious. You certainly want to advocate, but it's not as contentious as the typical litigation case would be. So you can choose an opportunity that fits well with your personality, which is, I think, different than a number of other specialties. Also, the fact that it is, I think, less recession prone. Oftentimes, the intellectual property of a corporation or other organizations is something that they need to continue to develop or as part of their overall strategic plan. Also, with patents, we see that the research and development expenditures, oftentimes they may be scaled back some, but it's still a critical aspect of a corporation's future, and therefore, again, you're less prone to the effects of recessions.
And Lewis says one thing that makes this practice unique is the exclusivity, because of the extra bar exam required to work with patents.
In the past, there's not been a lot of interest by very many students in the area of patent and trademark law. I think to some extent it was because of the requirement of the Patent and Trademark Office that you needed to have the scientific background in order to take the patent bar exam. Today, and I would say certainly for the last 10 years, the desire to practice law in the patent and trademark field is very, very much on the top of mind of many law students. They look at it as being an exciting area to practice in. It clearly is an area where there's much more litigation than there's ever been in the past, and I think that's going to continue. So I think that the combination of having the ability to be a little more exclusive than, say, lawyers in the typical areas of the law is probably attractive to law students. And what I'm talking about applies both in the private practice and in the corporate world. The corporate world is much more attuned right now, I think, to having strong patent counsel and trademark counsel in-house. So there is a little bit, I think, of the idea of exclusivity, because you have to take this patent bar exam in order to pass it in order to practice in patent law, something that doesn't exist in other fields of the law.
Finally, our guest offers some final advice for those interested in intellectual property law. And Jerry says it's a great opportunity for many different personalities, and there's a lot of resources out there for those who are interested.
Well, there are very many different resources. Your bar associations have resources regarding the careers in intellectual property law. Additionally, a lot of practitioners like me are happy to talk to prospective intellectual property lawyers while they're in law school to help guide them as well. And then the opportunities, they can certainly see the opportunities with either government agencies or corporations or other organizations. There's a lot of information available there, so certainly do check that out. But I think that oftentimes talking to those of us who are already practicing, we don't market it. We really do try to provide a very straightforward overview of what we see in the field now and in the future as well.
And Lewis says to be involved with intellectual property, it is best to plan and prepare early so you can have the requirements needed.
It's probably hard when you're going to college, unless engineering and science is something that just naturally you are inclined to think as something you want to study, to when you're an undergraduate, plan that you're going to go to law school and plan that you're going to be a patent attorney. So if that is something you think you're going to do, you got to decide that you're going to do it early when you're in college, so you'll have the science degree so you can take the patent bar exam. But I think just overall, patent law is no different than any other area of the law, in that as a law school student, you want to be the best prepared graduate of law school that you possibly can be, which means, excelling at law school, being involved in student bar associations, being involved in your community, doing everything that you can to make yourself stand out from the, if you will, the crowd of law school graduates. So to the extent that you want to excel as a lawyer, you got to do everything you can do to make sure you excel as a law school student, whether you're interested in IP law or whether you're interested in being a trust and estate lawyer.
Thank you for listening to PowerScore's podcast series. If you want more information on PowerScore's podcasts or services, please visit PowerScore.com, or you can call 1-800-545-1750.